Moderating today will be Professor Neil Kinkoff, a professor of law at Georgia State University. During the Clinton administration, Professor Kinkoff was a special assistant in the Department of Justice's Office of Legal Counsel, where his practice focused on issues of presidential power. He also served in the Department of Justice's Office of Legal Policy and has written and spoken extensively on the topic of impeachment. Tomorrow, he will be providing our remarks on the current impeachment inquiry tomorrow over lunch. Professor Kinkoff is an active member of the Board of Advisors for the ACS Georgia Lawyer Chapter and is currently serving as a faculty advisor for the ACS chapter at Georgia State University. And without further ado, I will turn it over now to Professor Kinkoff to introduce the rest of the panelists.
Okay, great. Thank you, Jordan. We have a terrific panel that probably doesn't need an introduction if you watch television and all. I feel like Chris Matthews or something. I'm here with this distinguished panel. But I will give a brief introduction. To my immediate left, I have Barb McQuaid, the former U.S. Attorney for the Eastern District of Michigan, which is centered in Detroit, and currently on the faculty at the University of Michigan Law School. Then we have Elliot Williams, who is a principal with the Rabin Group. Before that, he was Deputy Assistant Attorney General in the Office of Legislative Affairs at the Justice Department, which is the Justice Department's kind of lobbying arm and the arm that does congressional relations. And before DOJ, he was with Senator Schumer as his legislative counsel, right? Judiciary counsel, right? Yeah. Okay. And then at the end, we have Erica Newland, who is also a former OLC lawyer. Erica now is with Protect Democracy. Okay. So this is a really great panel to talk about the rule of law and the Justice Department, and boy, what a time to talk about rule of law and the Justice Department. So this is where I get to say I told you so. Last January, I testified at William Barr's confirmation hearing, and I testified in opposition to his nomination, and I testified against it on the grounds of his views about executive privilege. It turns out I really only scratched the surface of just how bad an attorney general he would end up being and how bad he would end up being for the Justice Department. But now we get to delve into that at great length. Okay. So I just want to start by talking about Bill's excellent adventure across Europe, gathering dirt and investigating the investigation. Okay. So Barb, I don't know, do you have thoughts on the investigation of the investigation?
Thanks, Neil. I do, and thanks very much for the invitation to be here. I'm delighted to be here, and I appreciate the question and the invitation. You know, I have great affection for the Department of Justice. I think it is one of the great institutions in our country. When I was there, Eric Holder and then Loretta Lynch were the attorneys general, and Loretta Lynch always said that the Department of Justice is the only cabinet agency named for an ideal. And justice is an ideal, sometimes elusive, sometimes more elusive than others. And one of the things that was always ingrained in us is that it's important that the Department of Justice not only be fair, but that it be perceived as fair if it is going to have legitimacy. And I am concerned that many of the things that William Barr is doing are damaging that perception of fairness. You know, things like referring to court-ordered surveillance as spying, for example, is just not something that most attorneys general use. But this idea of investigating the investigators, certainly investigators should be held accountable. They should follow all appropriate rules, and if they don't do that, they should be brought to justice for that. But there's just no evidence that anything wrong has happened here. And for William Barr, the Attorney General, to not only be authorizing this investigation, but to be traveling around the world himself to conduct the investigation. I don't know what it is he's looking at. There's obviously information he has that I don't, but it creates this perception that he is partnering with President Trump on a witch hunt to undermine the investigation that concluded that Russia was behind the interference in our election, and that there were these, you know, at least welcoming acts and conduct by the Trump campaign as found in the Mueller investigation. And I worry about the chilling effect that that might have on investigators going forward. You know, I sometimes heard FBI agents say critically of their colleagues, "He who does nothing wrong." And that was sort of the idea that you keep your head down, you can't get in any trouble, no worries. But of course, the person who keeps his head down isn't getting anything done either and is not protecting this nation. And so I worry that the chilling effect that William Barr's activity will have will actually harm our national security.
It's like a Quaker prayer meeting. I've been compelled to speak, and I will. I've been filled with the spirit of the word. But related to all that, it's important to step back and remember that every time there's a new presidential administration, a new crop of folks will come in and set priorities, policy priorities, and there are naturally going to be differences across how they conduct oversight, how they manage their affairs, and so on. That's a perfectly natural and perfectly acceptable component of the process. And even looking at some of the big, and we'll talk a little bit about Congress too and how they fit into all this too, but some of the big dust-ups over Bush and Obama over the last few years. So looking at the Bush administration, civil liberties changes under the Bush administration were in effect differences in policy. They were profound policy differences, and many people would regard them as tragedies, but they're policy differences, right? With how many, I think everyone in this room would have conducted the foreign policy or civil liberties of the administration. The U.S. attorney scandal, also under the Bush administration, again was a matter of personnel gone horribly wrong, but once that was excised and looked at by Congress, ultimately the problem, I think, got fixed. I was there, I was with the Senate Judiciary Committee, and so on. The interesting thing here, and this is what ties in to the bill's excellent adventure, is that what we are seeing is a fundamental reshaping of the role of Attorney General. Now, the question is this an aberration that goes away and expires when William Barr is gone or when Donald Trump is gone? Spoiler alert, the answer is yes. But is it an aberration, or have they just changed the nature of the role of Attorney General? And the interesting thing about this excellent adventure point, it's not just an investigation that we don't agree with. The problem is that it is a personal crusade of the president who is fixated on Hillary Clinton and fixated on the 2016 election, and Barr is being deputized to investigate that. So the problem, I think, and we'll talk about this through today, the problem is how the president views the role of Attorney General. And do we now have an Attorney General who is in effect the president's personal attorney who carries out missions like going to foreign countries to investigate his pet project, or an independent attorney general? And I think that's the great tragedy of all this. We've moved beyond the policy differences. And I could have, if you take the Civil Rights Division, for instance, I can get behind the fact that a Republican administration is going to have a civil rights policy that would not be one that I would carry out. But this is something totally different and far more toxic, I think, to the structure of government and who we are as an independent Justice Department.
Oh, I have one of my own. Okay, great. I'll just add one thing onto Elliot's point, which is I think that in addition to this Bill's excellent adventure, raising questions about how, or showing us, really illustrating for us, how Trump views his attorney general, which is something he's been clear about, frankly, since the get-go. It also raises some really hard questions about how some of the attorneys at DOJ and anyone else who is supporting this excellent adventure view the role of the Department of Justice more broadly. I think we'll talk about this in more detail. One of the most disturbing things, so I was at the Office of Legal Counsel from August of 2016 through about November of 2018. And one of the most disturbing shifts that I saw was a shift from looking to the best view of the law with a thumb on the scale of the executive, which was the job of my office, to what is best for the president. And when you have the harnessing of the extraordinary prosecutorial and investigative authorities of the Department of Justice, just if they shift just a little bit toward the president's best personal interests and away from the best interest of the country, however defined, with policy differences in mind, you're in a really, really scary situation.
Can I ask you a question? Sorry to I'm taking this panel over. But can I ask you a question on that? What does it mean? What does that thumb on the scale point mean? Because I think a lot of people have a question about what is the proper role of OLC, and to some extent, and this gets back to somewhat what I was talking about too, which is that perhaps a different crop of folks is going to have a different view of the law and a different view of constitutional interpretation than a subsequent or preceding administration. So where have we gone horribly wrong? And I'm curious about that to the OLC person.
Well, no, that's fine. But before you answer that, Erica, can you explain what OLC is? Because not everybody's going to know.
Absolutely, and I'll also caveat with, I think like Neil, he was saying right before this, I'm a bit of a heretic. I can't say that word with respect to OLC, so I'm going to talk about kind of how the office sees itself without necessarily endorsing that view. So the Office of Legal Counsel sits within the Department of Justice, and its job is kind of in the same way that the White House counsel is looking at tough legal questions, relating to presidential power or relating to agency power, so is OLC. But where the White House counsel has traditionally been staffed completely with political appointees and with folks who really do see themselves as looking out for the president, of course the president who's carrying out his oath of office, the Office of Legal Counsel has traditionally understood its role as protecting the office of the presidency, no matter who that president is. So making sure that the laws are carried out and that they are carried out in a way that does not undermine the ability of any future, this president or any future president to carry out his oath and make sure that the government functions. Neil, is there anything you want to add to that from your
I guess
time?
I would just say, so the office's origin is as a branch of the Solicitor General's office, and it was known as the adjudications branch. So when two entities within the executive branch would disagree on legal authority, OLC would resolve the dispute. So they were the in-house lawyers in that way. They also then, when they split off, were assigned the Attorney General's power to give legal advice to the president and the rest of the executive branch. And the tradition is for them to give kind of their best view of what the law allows and what the law forbids, and to not be advocates, which is what the rest of the Justice Department does, right? So the idea is the president's thinking about doing something, I don't know, pulling troops out of Syria or something like that, and goes to OLC and asks for their legal advice, am I allowed to do this? And OLC is supposed to give sort of straight up legal advice, and especially on issues like that, or like I want to bomb someplace, issues that aren't going to go to court, OLC really becomes the last word. And so it's an important office, and it performs a really crucial function. Those of us who've worked in the office, I think, tend to hold it in very high regard, although we can think of kind of low points like the torture memo, which was an OLC work product. But then you can think of what Jack Goldsmith did with John Ashcroft and sort of standing up against domestic surveillance. That's kind of the proud tradition of OLC. And so that's the role it's supposed to perform, right? But so then Elliot's question.
And there is some tension between the popular perception of OLC and the purpose. Many commentators, the media, I think often in the legal field, there's a lot of talk about OLC's opinions as lending legitimacy to the work that that the executive branch does, whether that's the agencies or the White House. There's some tension there with the structure of the office and the precedent of the office, and this goes to Elliot's question. So the office right now has probably about 22 attorneys. I think 5 or 6 of them are political appointees. And for folks who are familiar with the structure of the Department of Justice, that is very, very heavy on political appointees. So when you have an office that on the one hand is supposed to be giving a straight view of the law, and kind of some people analogize it to a Supreme Court for the executive branch, in part because it's the final say on a lot of really tough questions, but then you have a structure that is by nature going to tilt a little bit political. You have to question whether form and function actually meet there. In addition to that, OLC's precedent, because the history of the office comes from its role within the Solicitor General's office, and then helping carry out the Attorney General's function of providing the president with legal advice. long before the office was thought of, it arose in the Carter administration or so, that was kind of thought of as, say, a Supreme Court, as this more neutral arbiter. The precedent really is strongly in favor of executive power. And this comes from a Madisonian view, right, that, you know, the branches are going to fight each other, Congress is going to put its best foot forward, the executive is going to put its best foot forward, and justice will somehow prevail. And that's not how our structure really works these days, but that is kind of the beating heart of how OLC justifies itself and how the precedent kind of has a ratcheting effect. At least it has since the beginning of the Reagan administration.
So in that connection, I think it might be interesting to hear your impressions about what happened with the whistleblower complaint, right? When it was referred to the Justice Department, and within the Justice Department, OLC wrote an opinion. What did you all think about that episode?
I guess I'll start and then stop dominating the conversation. I had 3 takeaways from that opinion. The first was that strictly on the law, it wasn't crazy. I thought it was consistent with what you might have seen out of a past OLC. As I said before, OLC tends to be skeptical of congressional power, very skeptical of inspectors general. There was an incident in the Obama administration where OLC read a statute that was empowering inspectors general. It read it really narrowly, and then Congress never does anything, right? But they go and they actually clarify the statute to say that OLC was wrong. So in that sense, there was some consistency there. On the other hand, it's not the legal analysis that I would have done. I think it gave short shrift to the purpose of the statute. But the third thing, and the thing that really stuck out to me was not the legal analysis. It was the dicta, and it was the snark about the whistleblower maybe being motivated by political beliefs, about hearsay. That had, for those who are familiar with the opinion, I'm not presuming that folks are, that had nothing to do with the legal analysis and the actual conclusion that was reached. That was completely gratuitous, and I think it undermines the role of OLC because it, again, suggests that the office is just trying to do the Attorney General's bidding or the President's bidding and not actually giving a fair shake to the legal analysis.
Barb, Elliott, did you have anything you wanted to throw in on that?
The only thing I would add, really probably amplifying one of the points you just made, is that procedurally, you said not giving credit to the purpose of the whistleblower statute. The idea is that someone who has come forward with fraud, waste, or abuse and shares it with their inspector general, it's supposed to then go to the director of national intelligence, who shall advance it to the intelligence committees of Congress. It doesn't say, take a side trip over to the White House and Department of Justice and ask them what they think. The very people about whom the complaint is made get to weigh in on whether this advances to Congress. That just can't be right under the Whistleblower Protection Act. And so I have a problem with the fact that he went there in the first place and they took on the question. It seems like it says shall advance, and he should have gone directly to go, do not pass go, do not collect $200, go directly to the congressional committees.
Yeah, so I'd agree, Barb, and I would even go a little further. So the statute refers to matters of urgent concern and then defines urgent concern to include operations of intelligence activities. And initially, I thought it wasn't obvious that the whistleblower's complaint involved intelligence activities until we saw the complaint. And once we saw the complaint, right, so initially it's just a phone call with the leader of Ukraine, and what's that have to do with intelligence activities and releasing arms or money for arms? What's that have to do with intelligence, right? But once you read the complaint, you see it's about how is that call being stored, right? The server in the White House, which has to do with classified information, which is a classic operation of intelligence. And so then it looks like OLC isn't just throwing in snarky dicta, but actually is sort of manipulating the record to get to the legal result that they want to reach, which I don't think it takes too much connecting dots to say is something that's being dictated by the Attorney General.
So one thing that was this reminds me of, and that was concerning to me when I was at OLC. And Neil, I'm curious if you had a similar experience, because I don't, frankly, have the perspective to be able to say whether this was unique to this administration or applied in past administrations. The White House was really good at, or OLC would often let the White House dictate which question was asked. So a lot of facts might come into our, come to our attention. There might be a lot of different ways that you could approach the legal analysis, and they would say, we only want you to look at this one narrow thing. So for example, was the fact of the call a matter of urgent concern, as opposed to how was the information being stored, and whether that implicated the the obligation to go to Congress. And that raises questions about whether OLC is actually giving the type of legal advice that one would expect counsel to give.
Right. So, in the way it was done here, right, they were asked for an opinion which was immediately released the day before the whistleblower complaint itself was released, and it's clear what was going on was not an earnest request for legal advice, but rather for a memo that could be distributed to the public to undermine the credibility of the whistleblower's complaint, which starts to sound an awful lot like of a piece with what Barr did with the Mueller report, right, undermining it before it was released. So deeply problematic, right? That's not the kind of thing, OLC would not have done that, I think, back during the Clinton years, and shouldn't do that in any administration. So Elliot, I wanted to follow up on another, this is an area that OLC does a lot of work in as well, but executive privilege, right? So in terms of the administration's posture with respect to cooperating with Congress or not on investigations and the ongoing inquiries, how do you assess the department's position?
It's not good.
Good.
No, I think I should give more. It's dark. Yes, the Republic is falling. Okay, so back up. I think January 3rd, 2019 is the first time, I think, President Trump tweets the words presidential harassment. And I think that time, I don't think it was in all caps presidential harassment, but I think it was, if they go down this road, it will be an act of presidential harassment or whatever. So from the moment a Democratic majority took over, the president made clear how he and the administration would regard any attempt to investigate, oversee, manage, pick your verb, the executive branch. Now, to some extent, you saw some of that in the first 2 years of the administration, but it really, it hit fever dream pitch at the beginning of this year. And consistently since then, what you've seen is a historic level of, you hear it with TV, the UTV people use the term stonewalling a lot, but it's because it's sort of, to compare to past administrations, like even taking, so let's look at something that I was there for, Fast and Furious. It ended in litigation. So Fast and Furious, as you remember, it was a scandal involving the Departments of Homeland Security and Justice involving firearms getting into the hands of Mexican cartels. Big oversight dust up between the Congress and the executive branch that ended in litigation and ultimately ended in documents being produced and turned over. Yes, it was a fight. Yes, it was an epic clash between branches of government, but there was a fundamental respect between the branches of government that Congress has. For its ability to do its job, Congress has to seek information. The executive branch does have some space where it can claim executive privilege, and through a negotiation process that may end in litigation, that's where you end up. And I mentioned the U.S. Attorney scandal from the Bush administration. Same thing. Both sides were entitled to dig in as to their positions, but at the end of the day, it ended in litigation, the courts resolved it, and so on. That doesn't exist here, and the administration has simply chosen to approach any investigation or oversight by Congress as an act of harassment. And you've seen it even before you get to the assertions of privilege. So Steve Mnuchin, the Treasury Secretary, sitting at an oversight hearing with Maxine Waters, complaining about the fact that he had an important meeting to get to. Literally, this committee determines to some extent, his right to exist as a member of government. But well, I have somewhere else to be. Or Wilbur Ross at one point not showing up to his budget hearing because of the fact that, other people in the department can do it. So it's an attitude of disrespect for Congress generally. Now, when you get to this question of these assertions of privilege, and again, as you know well from OLC, a presidential administration has a right to assert privilege over a class of communications within the executive branch, within the president, among the president and his advisors, and that's fine. And if the government were functioning properly, we would have that. But what they've chosen to do is use executive privilege as a sword, not even a shield, to prevent any sort of testimony. Clearest example of it right now is Rudy Giuliani engaging in conduct that is not even. Number one, he's the president's lawyer, but sort of deputized as Secretary of State, kind of. But claiming various privileges, both attorney-client and executive, simply as a means of not providing information to Congress. And you're seeing that across the administration. So yes, there should be, and there ought to, I will stipulate, for the government to work well, and I think for the executive branch to work well, the president has to have some degree of protection and confidentiality of his conversations with senior officials. We shouldn't agree with that. Even Donald Trump, even a disastrous president, is entitled to speak with his aides in a confidential manner to some extent. But what they've chosen to do is frustrate any oversight with these sham assertions of privilege. I hope that answers your question.
It does, although the White House really hasn't actually asserted executive privilege, right?
They've threatened to, and no, there have not been formal assertions of privilege. They have simply said, and I guess this is complex legally, but they've simply said, we're just not going to provide those documents. This gets back to the harassment point I'd raised earlier, which is that anytime, if you undermine the legitimacy of Congress as an institution and just call them political, they have behaved in a manner that has given them the right, or they feel has given them the right, to simply not comply with anything. With one caveat, it's interesting. It does feel like there are two different postures that the administration has had. One is sort of pre-impeachment, one post-impeachment, because people are actually going in to testify before Congress now, and including current staff, and they've attempted to curtail testimony in a few instances. That they've sat down with. I'm trying to think of who. If Sondland had a conversation before, the ambassador to the EU, I believe. He had the conversation prior that these are the areas we don't want you talking about, but there was never a point at which they just blocked his testimony in a manner that they were getting away with 3 or 4 months ago.
Right. Yep, Mark.
I'll just amplify that point. One of the things, as you said 3 or 4 months ago, we saw the assertion not only of executive privilege, but something they called executive immunity, absolute immunity. So the president cannot be called to testify. He does have absolute immunity from testifying before Congress. But by extension, they said anybody who works for the president also enjoys this same immunity and doesn't have to testify before Congress. And so that was the way they used to block Don McGahn, for example, from coming in and testifying, and Hope Hicks about her time in the White House. You don't have to go in there and testify at all under this immunity. There's been one and only one court case to interpret this argument. That was a case back in the U.S. Attorney scandal involving Harriet Miers, who was the White House counsel, and a district court judge in Washington rejected that theory and said, no, that's ridiculous. You would apply that to everybody who works in the executive branch. No, executive privilege is recognized, but it must be asserted on a question-by-question basis, as you say, to protect things that are genuinely privileged. It isn't a blanket. And you may recall that Hope Hicks refused to testify even like the location of her desk within the White House under this executive immunity theory. That single district court opinion was later invalidated somehow because the case was settled based on a negotiation through the accommodation process. And so it doesn't stand as precedent, but to the extent we've had one judge issue an opinion on it, that's the opinion, that no, that's ridiculous, such a thing does not exist. OLC supported that theory, that there is such a thing as this idea of absolute executive immunity. And my concern is that when you go too far like that, and it is clearly at odds with our notion in our Constitution of 3 co-equal branches of government, the effect of this is going to be to actually harm the presidency, because it's going to erode this idea of executive privilege. And so when the next president wants to assert executive privilege narrowly and appropriately, people are going to say, oh, executive privilege, that's that thing that President Trump abused all the time. And so I think it is, in this odd sort of way, actually eroding the powers of the presidency.
One more. Because, we also explain what OLC is. We should also explain the accommodations process you talked about there, which is quite fundamental, and I think folks who haven't worked in Congress may not be intimately familiar with. But every time there is an oversight request of any kind from Congress, there is, or there ought to be, again, if the Republic were not falling, there ought to be a process whereby the White House or even somewhere in the executive branch, we did this in Justice Department Legislative Affairs, will negotiate over the scope and terms of testimony. So for instance, if you're paying close attention to the impeachment matter, now, if you notice some of the interviews are depositions where agency counsel may not be present. Some of them are transcribed interviews where agency counsel can be present. Some of them are open hearings. Some of them are hearings on the record but closed to the public. So, and this is all negotiated based on the nature of the testimony, if it's incredibly sensitive national security matters or whatever. If it's just a witness who ought not to be testifying in public, the whistleblower will probably not testify in public, and so on. There should be an accommodations process where both sides are negotiating over the scope and terms of testimony, but that just hasn't really existed in this administration. And the initial question was, let's talk about executive privilege, but I think it's bigger than that, because the current administration has used executive privilege as but one tactic in a broader pattern of simply disregarding Congress's ability or entitlement, for lack of a better term, to oversee it, in the Schoolhouse Rock three-ring government, in the 3 rings of government, one of them ought to oversee the other one, and they've just sort of taken that off the table, and the privilege assertions are just one of many tools they're using.
Right. Yeah, and the reason I raised that the administration really hasn't formally asserted executive privilege is, I think, the point you're making is really important. More what they've relied on is you have no authority to request the information in the first place, right? And so they've said that with respect to the tax returns. Cipolloni's letter relating to impeachment makes that point, right, that this is all beyond the scope of your authority. And they've made that point over and over again. And if that's their position, and it is, then there's nothing to negotiate about, right? You'll get nothing. Right?
And that
the
letter
from The Godfather. That's my offer. Nothing.
Nothing. The Cipolloni's letter, and we were talking about this before, it was a truly remarkable bit of legal analysis, because much of it was devoted to the partisan nature of which is just, that is bizarre. It is Congress's, regardless of whether the fact you don't like the fact that Democrats are running Congress, they are a branch of government with the authority to issue subpoenas and investigate and administrate. You don't have to like it, but that's the way our system of government seems to have worked quite well for 2+ centuries. But that letter was remarkable in that sense, in the way they attacked Congress itself as a partisan body.
So what can we do about it? Anybody have an idea? So the Trump administration is saying, we're not giving you anything.
Well, number one, I think obstruction of Congress is an impeachable offense. And I think that for too long, Congress has been looking at whether impeachment is a politically savvy choice. I think Nancy Pelosi was holding back on impeachment, thinking about what would be the consequence of impeachment on the November 2020 elections. And I think that the Ukraine scandal has finally caused her to say, regardless of the political impact this has, or maybe because she now perceives a positive political impact, it's a duty of Congress to hold the president accountable. So it isn't just, let's make the president look bad so we get to win the next election, but as a co-equal branch of government, at some point we have an obligation to enforce these powers, to stand up and defend the mission of Congress, if you will, by saying that this is not acceptable. So regardless of the outcome of the Ukraine investigation, it seems that the stonewalling, the administration also controls the NSA, which controls our signals communications. But I will not be silenced. So I think that's one way of holding the president accountable, is to say, we will not tolerate this kind of behavior. We're going to hold that impeachable, and an article of impeachment, as it was with President Nixon, is the idea of obstruction of Congress. Your stonewalling in itself is an abuse of power of the presidency.
Is there anything else that Congress can do? And the reason I ask is, I think that tactic, first of all, it's a sort of nuclear option, and it's a tactic that runs the risk that Donald Trump is running with over-asserting executive privilege. He may end up undermining that principle, right? If Nancy Pelosi proceeds with an impeachment that's going to fail, what you end up doing then is demonstrating that impeachment is not a way of bringing a president to heel with respect to complying with oversight. And so is there something, because I'm not sure we're going to get 2/3 to convict on that point. Maybe, but is there something else that might be available?
Oh, I think one thing has one avenue, and this is a little wonkish, but they haven't sued, and there is still another branch of government where, again, assuming the government is functioning properly, another branch of government ought to be mediating these disputes. And the examples I gave before, Fast and Furious and Harriet Myers, all ended up in the courts. So what they can do now, short of electing a new president or short of impeaching a president, is issue the subpoenas, the first step in the accommodations process would be invite people to testify. If they don't come, issue subpoenas. If they don't honor the subpoenas, sue for contempt, sue for whatever else, and see how the courts play. That's the official governmental process. Outside of that, yes, they can impeach, and an obstruction of Congress ought to be. And at this point, it's clear that they have the predicate for an obstruction of Congress article.
And then how about the strategy? So you're right, and we've seen a lawsuit filed, I think, in the Southern District of New York, in response to the position taken by the administration that they need not comply with a subpoena because the president not only cannot be charged, but cannot even be investigated. And so we've seen an appeal of that decision, and is there not perhaps a strategy to slow walk these things through the courts so that if they can just get a delay on all these things until November 2020, it'll be too late and there'll be a re-election, and then perhaps the appetite for impeachment will subside. Is there a way to combat that in our court system, you think? I don't know, Erica, if you have thoughts, or Elliot, if you have thoughts.
No, because ultimately, what was described in that pleading was essentially the legal basis for I could shoot someone on Fifth Avenue and get away with it, because they literally said that there is simply no legal process that can hold a president of the United States accountable, and that cannot be what the framers intended. Even assuming the legitimacy of the fact that a sitting president can't be indicted from the OLC opinion, even assuming the legitimacy, it can't be the case that a president can't be civilly sued or criminally investigated for anything. That's foolish.
Right, although the history of fights over executive privilege and document production is one that sort of gives a lot of support to the slow walking strategy, because these cases, courts don't like to answer the question, right? They keep kicking it back and saying negotiate some more, and years go by.
So, I mean, this isn't a solution to our current crisis, but in the medium to longer term, what Congress can do is legislate and give more jurisdiction to the courts, create timelines, create deadlines. One of the topics here is rule of law and DOJ norms. And a lot of what is happening through this accommodation process is really relying on a set of norms that presumes a certain level of good faith. Good faith by Congress, good faith by the executive. Everyone's really trying to do their best in the interest of the country as they see it. And what we're seeing is a breakdown in those assumptions, right? A proof that, that they don't apply here. And one reaction when norms break down is to pass laws to fix it. Not going to happen in this Congress, but a project hopefully for the next one.
So what laws?
Oh, God. I have a really long wish list. On the specific, question of congressional oversight authority, you can, as I said, create timelines to, compliance deadlines for the executive, at which point, DDC or whatever, the appropriate, but it's going to be DDC, court has jurisdiction to weigh in on with, tight timelines for appeal. Basically, the way that that the Solicitor General's office has been running litigation for the department during this administration, which is, constantly seek emergency stays and emergency appeals to the Supreme Court. More generally, there's a lot that Congress, of course, can do to take back its power. And I think, Elliot, you were making this point before to assert its prerogatives, or I'm sorry, Barb, it was your point about about congressional duties, and that is an oversight that is also in legislation in taking back some of the power it's delegated to the president on things like national emergencies and war powers, places where Congress has been happy to say, I don't want responsibility. That is kind of taking us in a whole different direction, so I don't want to go into too much detail there.
Well, I guess another kind of law reform point I'd like to have some discussion of is this question about indicting a sitting president, right? First of all, Congress is considering some proposals to allow for the indictment of a sitting president. I'm really not exactly sure how that would work, at least as a direct matter. But are there ways to hold a criminal president accountable to law?
So one observation I would make is, I know Neil and Erica, you both worked at OLC and perhaps feel fondly toward it, so no offense, but do you think it's any coincidence that the two OLC offices that found that a sitting president cannot be indicted were in the very administration of those presidents, right? The Nixon administration found that president can't be indicted when Nixon was being looked at, and the Clinton administration OLC found that the president can't be indicted when it was Clinton. And so there's quite a correlation between the opinions of OLC being favorable to the president and the presidency in which they serve. And I think that's the point that you made, Erica, that there's a political component to these. And so I don't think it's gospel that they have, just because we have two administrations, of both parties making the same finding, that is etched in stone. And I think the place where you might see a challenge to it, until this is worked out by the courts, I don't know that we have a sound answer to it. It would be really interesting to see a state court prosecute. I don't think we're ever going to see DOJ indict a sitting president because they're going to follow that policy within the department. But, state of New York, Cy Vance on, we've got him. I don't know that the kind of thing like false business records is going to rise to the occasion, because not only do prosecutors consider, can we charge this person, they also consider, should we charge this person? And to charge a president, I think you're going to require a very egregious crime. But if President Trump were to shoot someone on Fifth Avenue, I think Cy Vance could and should charge him with a crime for that, and then we would see. And so I think it may make a difference whether it occurs within the scope of his powers as president, in which case impeachment is the right course, and if he commits a crime as in his capacity as a citizen, he's not a king. He has a job, and he also exists as a private citizen. And so if he were to shoot somebody that's certainly not within the scope of his powers as the president, I would think that Cy Vance could and should charge him with a crime for that.
So I may have drunk too much OLC Kool-Aid here. I'm pretty skeptical. On the federal level, in addition to just the pragmatic point that you made, I think the Constitution it's pretty clear that impeachment is the first step remedy when the president has broken the law. Obviously, the impeachment clause is very clear that it does not foreclose indictment after impeachment, but I think impeachment is how we deal with a president who's broken the law, whether that's shooting someone on Fifth Avenue or obstructing justice. I think when the states go about it, you have some real supremacy clause problems. I find it actually personally concerning that an elected attorney general in one state, maybe a really tiny state with a few 100,000 people, could, seek to put the president in prison.
Texas prosecutors would have indicted Barack Obama 5 times a day, every day of his presidency, if they're alerted to the fact that they can do that. So I agree that there are real federalism problems with a state indicting a sitting president. But I think there might be some other mechanisms for allowing, or at least getting it into court, right? And one mechanism would be, what if we revived the independent counsel statute? I'd be curious to know what people think about bringing that back, with maybe some kind of anti-Ken Starr provisions in it.
That's I am not the expert on the independent counsel statute, but to some extent it seems cyclical. It's you had the independent counsel statute. There were what many people regarded to be abuses of it during the Clinton administration. So we ended up with the special counsel, and now people are complaining that the special counsel didn't have enough teeth. So I don't know if the pendulum swings back. What I think you would be doing ultimately is rewriting the original independent counsel statute, but just trying to write away the problems that we had with Ken Starr. And that just seems like we're chasing solutions rather than, so I don't know if that's a solution, Neil, but again, this is not my area of expertise and I don't know, but anyway.
Okay.
I would advocate for a shot at it. It did survive constitutional review. People often look at the Scalia dissent from that as if it's the law and say the independent counsel statute was unconstitutional. Just look at what Scalia wrote in Morrison versus Olson. Well, that was a dissent. And so I think it was found to be constitutional. I think that it could be improved upon. It required a written report to the public, which I think gave Ken Starr this avenue to shout it from the rooftops and write the big, page turner. But, you could make it instead something that he delivers only to Congress for them to decide whether it's deserving of going further. So I think maybe that's the way the pendulum works. You go from one extreme that didn't quite work to another extreme that didn't quite work, and you keep narrowing and narrowing until you get to the sweet spot. So because I think I was hopeful that the special counsel provision would work well, but that presumed that you had honest brokers in place. And I think that when Robert Mueller delivered his report to William Barr, I think the intent was that this would be shared with Congress, and he declined to make a decision even whether a crime was committed because he thought it wasn't his place to do so under Erica's theory that it's only Congress that can find that a president has committed misconduct that can be remedied through impeachment. And so William Barr took that and stepped into that vacuum and said, well, if you can, I can, and I'll decide that there is no crime here, there's no obstruction, and we're done. And I don't think anyone foresaw that conduct occurring. I think that it presumed an honest broker in the Office of Attorney General. And so I think we do need to fix it, and maybe having something akin to that independent counsel statute is a way to get there.
Just to clarify one point, and I think you probably had heard me, Bart. I certainly wasn't raising a concern with the constitutionality of it, or trying to latch onto that Scalia. Yeah, okay, got it. Yeah, it's more. I just think because I'm thinking less of the independent counsel statute and the criticism thereof, and more about criticisms largely from the left about the way the special counsel regs played out in the context of the Mueller investigation, which is that I think people's concerns were largely about failings in William Barr. Now, again, maybe you could legislate around that, but my fear is, like I said it before, chasing solutions based on the peculiar circumstances of peculiar presidents.
I think there's an elephant in the room here, or maybe 5 elephants in the room. I would, if I were a betting person, I'd bet a significant amount of money that the current Supreme Court would adopt the Scalia dissent from Morrison v. Olson, which means they would hold that the independent counsel statute, if it were revitalized in the form that it was in leading up through the Clinton era, that they would hold it unconstitutional. They would hold it as a violation of the Appointments Clause. And I think that if there is an area where maybe the left has not fully appreciated a shift in constitutional doctrine and kind of constitutional moments on the right, it is the importance of the Appointments Clause to the lawyers currently at the Department of Justice, to the 5 conservatives on the Supreme Court. And I think that ties into our conversations about Bill Barr and Donald Trump, because the view is, it's this unitary executive view, and the view that the president's authority to kind of command and control everybody in the executive branch, independent agencies, attorneys, prosecutors, the CFPB, which we were talking about before this panel started, that authority is absolute, that it is innate, to appoint and then to remove, and that it cannot be messed with by Congress. So I think we would have a really hard time under this court reinstantiating that.
Well, I certainly agree with that. And the CFPB case is interesting, right? So what's going on in these cases is it's a fight over the president's ability to remove subordinates at will. That's how the president controls the executive branch, and we've seen this president do exactly that. That's why he says he likes to have acting secretaries instead of confirmed secretaries, because they're even easier to remove, right? And that's how he controls what goes on, right? And I was thinking about this during the last panel, that this concern seems kind of law professory, ivory tower, abstract, as opposed to the previous panel, which was just so compelling and immediate and pragmatic. But I promise you, the removal power is pragmatically really important. It's nerdy, but it really matters. And the administration understands that it matters. The president wants to be able to fire any investigator who might investigate him or Rudy Giuliani. And by the way, if we care about the Appointments Clause, isn't Rudy Giuliani then a public minister or consul who has not been appointed in a manner conforming with the Appointments Clause? Just wondering.
One quick point on that, not just the ability to terminate, the ability to appoint, and sort of a bee that's been in my bonnet for a long time on this very issue is, it's not just that we want Congress to, certainly you want Congress to approve senior officials with the full advice and consent and so on. There are certain roles that cannot be performed by an acting official. Signing FISA warrants, for instance. This came up in the context of when Sally Yates was acting Attorney General. Acting officials in some roles just can't perform the functions of government. So you are handicapping a number of key core functions of government when you rely heavily on acting officials. So the president can say all he wants about, I can move people in and out, but you're harming critical and sometimes even national security functions.
Can I chime in on that as well?
Sure.
And just to put an example on it, you may recall that when the Director of National Intelligence resigned, the presumptive acting DNI would be someone named Sue Gordon. And Trump said, I don't want you in that job, and demanded her resignation so that his hand-picked person, Joe Maguire, could be there. And sure enough, it's Joe Maguire who's the one who runs to the White House and OLC when he gets the whistleblower complaint and says, oh, what should I do about this, rather than complying with a law that says it shall advance to the intelligence committees of Congress.
And I'll add one of the, I think, scary things about the point that Elliot made is by disempowering acting officials in certain statutes like in FISA, I think there was an assumption that Congress and the president would really want these powers to be in place and therefore would feel incentivized in the interest of good governance to get someone confirmed. The fact that these incentives don't seem to be working the way that we expected goes back to this point that not everyone seems to be acting in good faith, and I think that's really, really scary from a how government runs perspective and future of the republic perspective.
Okay, right, and so the removal power, it's practically important in a lot of ways, right? You've mentioned any number of them. The Supreme Court this afternoon granted cert in the case challenging the constitutionality of the Consumer Financial Protection Bureau, right? Something that's really important for people taking out payday loans and the like. And that case hinges on a question of the president's removal power and whether it's an unconstitutional infringement to have a single-headed agency, an agency with a single head, who is not subject to the president's at-will removal authority. The Justice Department initially defended the constitutionality of that statute, which traditionally has been understood as the role of DOJ. Unless there is no legally viable argument, DOJ is supposed to stand up for the validity of the constitutionality of statutes, all of them, whether it likes them or not, right? This is the duty to faithfully execute the law. It's the president's duty to defend laws unless there is no legal argument available to defend them. Well, the Justice Department in this case, and it did it last year in another Appointments Clause case, Lucia, which had to do with administrative law judges at the SEC, the administration is declining to defend the constitutionality of these laws. And so the court has to appoint someone to step in and argue the other side of the case. And I'm wondering what you all think about DOJ's duty to defend and its seeming refusal to do so in this line of cases. Barb, did you have some?
So I do have some thoughts on it. I mean, you know, my understanding always was that DOJ are lawyers for the government, and their job is to defend statutes passed by Congress if there is any good faith legal argument that can be made. I think that where some of the arguments begin is during the Obama administration when the department declined to defend DOMA, the Defense of Marriage Act. You know, I've heard people distinguish them as saying there was no legally valid argument there. It was a constitutionally violating statute, and because they took that position that there was no good faith argument to be made, the Department of Justice should not defend it. And now I think this administration is using that as precedent whenever it just doesn't like the statute to say there's no good faith argument we can make. We're going, and not only not defending it, but reversing its position and saying this is, you know, an unconstitutional statute. I don't know if you all have thoughts on it.
I think this, so we've seen this in the ACA case as well. I think that, so I completely agree. I completely agree that kind of the excuse that folks are using is what happened in DOMA. I see differences there. They kind of whitewash those. Or they present the question, the CFPB question, the Lucia question, as a constitutional one, and then the ACA question too, and back to this kind of framing of the Appointments Clause as the clause on which the Constitution turns. When you conceptualize the Constitution that way, then, you know, any stepping on the toes of executive power becomes something that is of such importance that it can be described as justifying a departure from norms in some ways similar to what happened with DOMA. So I think they're playing word games with kind of the constitutional point as well.
Let's see, I think I could keep asking questions all day, but I think I'd like to open it up to the audience for questions. So if anybody has anything that's jumping out at you. Yeah.
Hi, thank you for the discussion. Several times there were mentions of, you know, presuming actors are acting in good faith or rational actors, and how that may not be good presumptions in the current climate. How should Congress go about drafting statutes moving forward without presuming good faith or rational actors in the other branches?
I think it's very challenging to do that because although you have the branches of government acting as checks on each other, at the end of the day, most of these jobs have a fair amount of discretion in them. And so you do have to have honorable people in place looking out for the best interests of the country, even if those values might be different. You know, Elliot raised the example of the Bush administration. The Bush administration had many policies that I would disagree with, but I never doubted that the goal was their vision of protecting America, right, from whatever threats they perceived. And I can't say the same is true with this administration. So, one hopes that exposing the flaws in candidates will help people to elect people who are honorable and care about the best interest of the country. And I think that you can have more oversight, more disclosure, more transparency. For example, requiring a presidential candidate to disclose his or her tax returns is a way to learn a little more about who they are and what interests might drive them. But there still are going to always be some things that require discretion, where you can't legislate everything. The other thing is, to what extent does this unitary executive theory stand? Because that makes it very difficult for Congress to put rules in place for the Department of Justice. For example, even an independent counsel, as Erica points out, could be struck down as violating the three-part, creating an unconstitutional fourth branch of government. And so it is difficult. So I think improving transparency, accountability, and disclosure is probably the best way that we can save ourselves from people who will be bad actors in exercising that discretion.
I'd say I agree completely with what Barb said. I'd say there are kind of three buckets of, and if criteria is quite the right word, that I would use in looking at legislation. So one is transparency. Senator Whitehouse and Congressman Jeffries have a bill right now to require disclosure of certain White House DOJ contacts. Can't prohibit all contacts, but you can require them to be shared with the public or to be shared with Congress, hoping that a little bit of sunlight will act as a disinfectant. That doesn't always work. We've seen that in this administration. I think it's Congressman Schiff has a bill right now about transparency relating to pardons and recommendations to the president around pardons. That's another example. Second, you can create constraints on decision making. So you can take some of the discretion out of decision makers, not all of it, and you don't want a government where no one has any discretion. And then the third thing is accountability. And there are two different things by accountability. So one is legal accountability, right? We see this, of course, when we're talking about police shootings and other places where public officials can act basically with impunity. But the second is social accountability. And one of the things that really struck me during my time at OLC in the Trump administration was that, in the Obama administration, folks were writing opinions, folks were thinking about, is this going to be taken seriously by judges, by our legal community on the left and the right. You are going to be citing, when you're in the Obama administration, you're going to be citing Bush-era precedents, because that's proof that what you're doing is legitimate. And in the Trump administration, I saw a real shift. If you look at the public opinions, they're focused more, the opinions that have been released publicly, they're focused more on Republican precedents, and there's this sense of wanting to speak to your crowd and please your people. And that's a really scary shift, and one I'm not sure kind of what to do about. But when you don't have those kind of social and professional norms pressuring people to behave well, you're also going to see the discretion used in ways that I think are not good.
Yeah, I would just add, I'm a little skeptical about how effective transparency is going to be, because this administration is perfectly transparent in their lawlessness, right? Just they tell you they've done it, and then they say, get over it. Elections have consequences, right? We hear that over and over again. I do really like Erica's idea, though, about trying to define discretion a bit more, because I think, Barb, you're absolutely right. You can't run a government where you don't have some discretion in the president. The president needs to be able to respond to things that happen. But statutes don't have to therefore give him blanket authority. They can say, here are the things you need to find before you're allowed to reprogram money to build a border wall, right? It doesn't have to be just say the words national emergency and suddenly your magic powers spring into action.
On all that, though, I do think someone correct me on this if I'm wrong. I think overwhelmingly the law presumes good faith on the part of actors. That is sort of how both criminal and civil statutes across the United States it's something that we have baked into the law. And I fear this rush to write bad faith, or to write laws around a presumption of bad faith because we have a particularly bad president. And maybe I actually am a closet conservative that believes that the rush to write laws around a particularly bad actor might come back to bite you. But it's right now there is a perfectly viable remedy for all of this, which is impeaching a president of the United States. Now, it seems like that's not working. But my great fear is not treating this administration as what it might be, which is an aberration, as opposed to an actual rethinking or reshaping of the role of the presidency or the role of the Justice Department or so on. I don't know the answer to that, and it's just more a thought or an idea, but I just fear, and this is, we were talking about this in another context earlier, rushing to write laws around the problem of Donald Trump when I think the problem is actually Donald Trump.
Oh, if Donald Trump gets away with stonewalling Congress, future presidents are not going to be any more cooperative, or at least, I don't know, I shouldn't say any more, but those precedents are going to operate for future presidents.
Fair, but run down, okay, not even the 84 people running for the Democratic nomination right now. I mean, even a Marco Rubio or Jeb Bush presidency would not have gotten you this. Now, you might have had some of the same policy outcomes. You would have probably had the same Supreme Court justices, let's be clear. But would you have had the same level of flagrant disrespect for the norms of separation of powers? And I just don't think that's the case. And I think what people thought they were getting with this president was a disruptive presence that's going to shake up how government works. And what you ended up getting was lawlessness and someone who was unfit for the presidency. But I just don't know, again, I'll say the point again, I just don't know if the problem is a defect in our system that has led to a door being too open, or if it's just, we just elected a really bad president.
Well, we clearly elected a really bad president, but I don't think that's the only problem, because a lot of what the president, the administration are doing, I hate to say this, is in a weird way principled. That is, it's based on this unitary executive theory that isn't going to go away. And when Marco Rubio is president, should heaven forfend that happen, he will rely on the precedents of the Trump administration and on the legal reasoning of the Trump administration.
I guess, wait.
Yeah.
I'll give you a chance to keep talking about this because I have questions that are on this same line. So, kind of along the same vein of whether this is an aberration or they successfully broke government and it's time to evolve it. Where do you go from here? I'm assuming that this sets precedents for future presidents who might not be quite so lawless, but will use some of the Trump administration's actions as precedent. Where do you go, and what is the future of the rule of law and our system of government look like from here?
So you legislate, you give Congress more capacity. Congress needs to build itself. They need more staff. They need more office space, more professional staff. They need to pay staff better. They need to, I really like Neil's border wall point, and I've been involved in some of the litigation on that. A president, even if you accept the unitary executive theory, which I don't, but let's accept it, the Supreme Court I think will largely accept it, the Supreme Court. The president may be entitled largely to his own interpretation of his or her own interpretation of the Constitution and the laws with a great deal of discretion. What he or she should not be entitled to are his or her own facts. And there are a number of things that happened with the National Emergency Declaration. We see this elsewhere, but the National Emergency Declaration is a really great example of it. First of all, the president has discretion, or president claimed discretion under the statute to call anything a national emergency and therefore to appropriate certain funds. But what he also claimed discretion to do was to make up facts about the border effectively. And he's done that again and again and again. Obviously, he does it when he's on the stump, but he also does it when he is using or claiming authorities that have purportedly been delegated to him by Congress. And so one thing, to go back to the, kind of buckets, accountability, transparency, constraints, one form of constraints would be to create opportunities for judicial review of fact-finding that say very clearly that this is not a political question, that we don't intend to delegate to the president the discretion to, say that the sky is green when the sky is in fact blue. And I think we've veered toward giving the president that discretion too much. And I think any administration, any good faith administration in the future is hopefully going to act within the realm of reality. And I think we will.
So one area that really interests me, and I'd love your perspectives on this, is the idea of the extent to which the president can control the Department of Justice. There's been this norm, really, where the president does not say, I'm going to direct the Department of Justice to investigate my political opponent. Remember during the debates when Trump said Hillary Clinton would be in jail in his administration, which is, really disturbing. Or to suggest that he can tell, Jim Comey to let this thing go with Mike Flynn. The idea that you're politicizing the decision-making of prosecutors or investigators is really antithetical to the work that I did as a prosecutor and the way we thought about ourselves. And in fact, we talked about this scandal of firing U.S. attorneys who were not loyal Bushies. The idea is we are independent from the president. We decide cases based on facts, law, evidence, not on politics. But there is, if you have this unitary executive theory, there is this idea that the president is in charge of all these departments in the cabinet, including the Department of Justice and the Attorney General. I am aware of some occasions during the Obama administration when, for a greater good, they asked prosecutors to stand down. In a case that I was working on, they asked us to stand down on Anwar al-Awlaki because they had other plans for him, being a drone strike. There was a case involving, drugs with Hamas, and I think for political reasons relating to negotiating, the nuclear agreement with Iran, some office was asked to stand down. And that's appropriate, right? Because it was putting a national interest ahead of a case. That seems to me appropriate. It's when the president is asking the Department of Justice to do something that's in his personal interest that I think it gets into a problematic area. And I don't know the answer to that because I think it would be difficult to legislate around that in a way that's constitutional. Maybe, you hold the president accountable politically by asking candidates to pledge to keeping the Department of Justice independent. Maybe, there are ways to enforce those norms without enacting laws around them. But I would love to hear the thoughts any of you have about that because it's one that troubles me.
And so back to Neil's point a little bit earlier about the rationality, or I think he used the term rational, or the principled nature of some. Look, it's an entirely principled view that the President of the United States ought to control the Justice Department because it is an arm of the executive branch. Principled. I'm not saying it's right, but it's consistent with the notion that as the titular sworn head of the executive branch, now, he's taken that to an extreme in a number of instances where, number one, he says, I could shut down the Mueller, I could have shut this whole thing down if I'd wanted to. He directs Jeff Sessions to investigate Hillary Clinton and now Ukraine and on down. The problem, and this gets back to when Neil and I were going back and forth a moment ago, look, Kamala Harris said it on the campaign trail and sort of stepped in it and had to walk it back. But it is a reflexive point to some extent that candidates people have a political interest in saying that as the president, I will use the Justice Department to effectuate a political goal or something. But again, I share Barbara's concern. I don't know how you restrict that other than get a better president or get somehow the notion that the Justice Department is independent needs to pervade both government and the public. And interesting, just not to go down the what if Obama road, which we go down a lot, but one of the first, when were you sworn in the first term in the very beginning? So there was an event with all the U.S. attorneys at it. Right, exactly. And so he gives, I'm telling you remarks you were at, but where he says, in effect, I put you here, but your confirmation is being confirmed makes you independent of me. And, you know, he said it more mellifluously than that. But the point is, you are no longer my arm. You are no longer my political agents by being confirmed here. You've never heard such a thing from Trump. And some of that is a political matter. It's just a better human being got elected president of the United States. Now, again, how do you legislate that? I don't know. And I wish I had a better answer for it.
Well, the other remedy, which ends up not being a great answer either, is Congress needs to have a spine, right? The whole system of checks and balances depends on Congress standing up to the president, and it doesn't have to go to the nuclear option of impeachment, right? You can retaliate against nominees, you can retaliate in terms of budgets, and there are all kinds of tools that Congress has at its disposal if it wants to use them. The problem is Congress doesn't particularly care to use them, in part because members of Congress who are members of the president's political party, their futures and fates are tied to the success of that president. They have every incentive, instead of loyalty to their institution, to have loyalty to their party. And so that's, I think, the key bug in our checks and balances system that prevents Congress from acting in the way Madison assumed it would act, which is as a check on the president. So it would be great if Congress did that. I don't have a lot of hope they're going to, right? The other thing we might hope about is public pressure, and that goes back then to Ben Franklin's thing about it's a republic if you can keep it, right? It's up to us, ultimately, and maybe Congress would find a spine if we demanded that they have a spine.
So I hate to add anything to that good sentiment, but I think there are a few additional things that Congress could do to legislate. Barb, I'd be really curious for your thoughts on them. And these are not really vetted ideas. But when we're talking about the criminal prosecutorial power of the Department of Justice, Congress has control over the rules of evidence. The presumptions can be created when the president or the attorney general makes comments about specific cases. There can be opportunities to get information about, that's not the way things work right now, but once the president has made a certain comment, maybe the department has to hand over certain files. Not necessarily advocating for that, but the due process implications. There's the faith in government implications. The president's a political actor. It's part of the reason I don't ascribe to the unitary executive theory, because I think we want to have bulwarks against that. But the due process implications, I think, can provide some legislative hooks as well. And I'll also, Elliot pointed out, I want to echo the budgetary point that Neil made. Congress, the courts often stay out of battles between Congress and the executive because they say Congress controls the budget. If Congress doesn't like how the attorney general or how the president is directing the attorney general to act, Congress can withdraw funds from the Department of Justice or from, can say that, funds may not be used for certain purposes. It does that all the time with controversial matters, abortion, being one of them.
No, those are good ideas, better than I've got. It's a challenge. What's the alternative to a unitary executive theory, though, right? I mean, I do think it makes logical sense that the Department of Justice is part of the executive branch, and ultimately the president can control it. That doesn't mean he should, and so most presidents have been kind of hands-off. But is there a way to prevent the president from being hands-on, or is there a different theory under which you can say the president can't control decisions of the Department of Justice?
I look to the president, to the take care clause, which has often been used by conservative lawyers to say that the obligation to take care that laws are faithfully executed means that the president has a lot of discretion. That's what take care means. I focus on faithful execution. And the idea that faithfulness means that the president has to live up to his oath, he has to be acting in the public interest, and he has to be acting honestly, back to facts. Sorry, lying just really bothers me. And so now that doesn't translate into a whole constitutional theory of governance necessarily. It's a starting point for one that may suggest restraints on the president's removal power and more authority for Congress when the president has acted in ways that are inconsistent with that obligation.
So I would locate the response in the necessary and proper clause. So There is a Department of Justice because Congress created it, because Congress has the specific textual authority to make all laws that are necessary and proper for carrying into execution all the powers of the government, not just its own sort of Commerce Clause powers, but to bring into effect the president's pardon power, right? And so Congress creates a pardon attorney. And it can also make a law that says it shall be a crime to bribe the pardon attorney, right? This is just common sense, and it's common sense that is located in the actual text of the Constitution. The problem with the unitary executive theory is it completely ignores the existence of the take care clause. And so that's the clause that authorizes Congress to create the Department of Justice, to say what it can do, what it can't do, and to establish that it should have measures of independence. Right? Now, whether that would allow Congress to make the Attorney General an independent officer, right, which Congress considered doing. There was serious consideration to that after Watergate, and instead the compromise was the independent counsel statute. But that's where the authority rests, and that's the problem with the unitary executive theory. Like so much in the Trump administration of its principle rests on ignoring the fact that Congress has significant countervailing powers. It does, right? It has the power to inquire and investigate, which the executive branch seems to ignore for some reason. And with respect to the removal power, the executive branch ignores, through the unitary executive theory, necessary and proper clause.
So an interesting idea here. We are accepting as gospel, particularly for prosecutors here, that the Justice Department, criminal investigation in particular, is just different, right? That the President of the United States, the White House, does not have the same authority to direct the affairs of the Justice Department that he might, the Department of Labor, or so on. And I think part of that is, how do you create, how do you, I mean, to some extent you would have to codify that concept, and I do, and wonder if maybe the solution is an independent attorney general. I know Neil just threw it out as an idea, but short of that, I'm not sure how you get around the fact that it is one of however many, 14, 15 cabinet departments. It's just one. And undermined by this idea of Justice Department specialness or independence, undermined by the fact that there are criminal investigators in most, if not all, cabinet departments. The State Department has the Diplomatic Security Service. They do have criminal investigative authority that I would think should and ought to be subject to the same limitations of, you don't want the president saying, you know, I want you to go investigate that ambassador, which is what the Diplomatic Security Service, it's the State Department's criminal investigators. That they would have the authority to do.
Right, and the post office is an independent
Yeah.
agency. They have postal inspectors, right?
Right.
So that this can be done. I wanted to ask another question. I'm sorry, I'm going to preempt the audience here, but should we hear chants of lock him up? And I guess what I mean to introduce by that is, assuming that the public sort of gets rational again and elects a Democrat next time around, right? So Donald Trump is not reelected. What would you all think about the Department of Justice pursuing a criminal prosecution of Donald Trump for obstruction of justice in connection with the Mueller report, some of the violations of campaign finance laws, maybe relating to Stormy Daniels or relating to the Ukraine matter? I'm curious to have your impressions about that.
So I think one thing you want to avoid is that after every president leaves office, he would be investigated and prosecuted as a political matter. But I think the conduct of this president has gone way beyond politics. His conduct with regard to obstruction of justice, to me, is absolutely clear. Robert Mueller found significant evidence that he had violated obstruction of justice laws. To me, the one that's most egregious is asking Don McGahn to create a false document to support his version of facts about what he had directed. That to me is clear obstruction of justice. And so I don't know, but again, just because you can charge someone with a crime doesn't mean you should charge someone with a crime. There are a number of things called principles of federal prosecution that you look at about how egregious the conduct was, who the actor was, whether there are other remedies available to address the harm. And so I think a prosecutor would have to look at all of those things to see what satisfied. We don't yet know all the facts of the Ukraine matter, but as that shakes out and we see, that strikes me as more in the realm of abuse of power and impeachment, impeachable offense as opposed to a criminal offense. But I think that it's absolutely within the realm of what is appropriate for prosecution based on a consideration of all of those factors.
And on the principles of prosecution point, and particularly the appearance point, I think you have several classes of Trump conduct, and the campaign finance, and particularly some of the financial matters generally, just appear to be more political to the public. I'm not, regardless of what you think about it, people regard it as, many people in the country regard it as politically motivated in a way that some of the conduct that took place during the president, and frankly, pursuant to his authority as president of the United States, I think is just a different class of conduct. So, any future Justice Department would just need to be incredibly careful about that. Prosecuting the president for not releasing his tax returns in the context of a campaign finance matter in New York is just going to look political, and I think you will, on this question of should you do it or can you do it, you just run into some problems there.
I'll add a couple thoughts. This really keeps me up at night. I really want accountability. But one thing that's clear to me is the presidential candidate shouldn't be calling for it. That's for the due process reasons and the faith in government reasons that we talked about earlier. I think of it as Twitter rules. Like, sometimes people tweet things and you're sitting there thinking, say that to your friend, maybe don't put it out there on Twitter. We can think that he may have committed many crimes, but it's not appropriate for the presidential candidate out on the stump to be saying, when I control the awesome prosecutorial powers of the United States, here's a person I want to incarcerate. The other thing, and frankly, I don't totally know that I'm settled on this, but that I spend time thinking about is his subordinates. Because his subordinates were an important part of, and I mean that both his subordinates before he became president and his subordinates as president have been important parts of potential criminal activity. And does it look less political when you go, if they are investigated, does it look more political? If a state does it rather than the federal government, is that better? I'm not totally sure, but that's something I spend some time thinking about.
Go to the microphone, or can I just speak up? So I want to ask a question that gets at the rule of law from maybe a little bit of a different angle. One of the hallmarks of the Trump Justice Department is seeking to skip the courts of appeals and go straight to the Department of Justice, particularly in politically sensitive cases, creating, in my view, the appearance that he thinks he's got the court in his pocket on anything that is political. And can you address number one, whether you think the Solicitor General's office is violating norms in doing that, and number two, sort of what you think the effect is on the rule of law or the perception of the rule of law?
There's a saying that I've been told is common at the SG's office these days, which is lose, lose, win. You lose below and you'll win at the Supreme Court. And I've also heard, although I wasn't there the day that the census opinion came down, that Bill Barr's face was one of complete shock when the administration did not completely prevail in that decision, because there is a presumption that having the Trump nominees in place means that the Supreme Court is secured. I think that is terrible for the rule of law. I think it's a really, really big problem. And I think, as you've pointed out, that skipping the courts of appeals just exacerbates that problem. I think it's not talked about enough. It's pretty simple. I don't have much more to say than that.
So I'll add on a positive, which is why we need more judges who come from the ACS community.
All right. Well, I think that's a good note to end on. Thank you to this panel. You've all been really wonderful and terrific. Can we have a round of applause for the panel? Okay. And then I guess we're off to the Carter Center, is that right, for dinner? Oh, okay.